My name is Brad Fouraker. I'm a practicing ophthalmologist in Tampa, Florida, and I'm also a board member with OMIC, the Ophthalmic Mutual Insurance Company. And I want to have this opportunity today to talk to you about the claims department in a malpractice company. Of course, many of us understand that claims departments are there, just as any other time, to help us if we have a major problem, a lawsuit that hits us. But claims departments actually do much more than that. All of us, of course, have insurance on our cars or our health or our life, our homes, things of that nature. And when something befalls any of those particular situations, then we put in a claim to the insurance company, and we hope that that insurance company will pay us on those particular claims. Malpractice cases, unfortunately, are quite different. We're the ones that are being asked to pay in that particular case, or the malpractice insurance company is being asked to pay. They're very personal, and quite frankly, I've been involved in lawsuits previously. They're very threatening. They really do personally affect you and emotionally affect you because it's demand by a patient, a written demand by a patient as a claim for you to reimburse them or to pay them in a particular situation. Now, what is a malpractice company and how does a malpractice company help us with claims? Well, first and foremost, they're there to protect our assets. Our assets are not only monetary, but our assets are also our professional reputation. All of us have spent many years studying, working hard. We all want the very best for our patients. That's what we try to do day in and day out. That's why we go to meetings like the American Academy meeting, the ASCRS meeting. All of those things are to better ourselves so we can better our care for our patients. So when someone accuses us of not falling below the normal standards, or certainly falling below the standards of their expectations, we all should take that personally, and our professional reputation is in fact on the line. So it does affect us not only professionally, but emotionally. What a company should do is to help us in the respect of acting as a barrier to protect our particular interest. It also helps us to form a defense for the actions that we have done. That claims company or that malpractice company should look over what we've done and help us to see what areas are deficient, alternatively, and what areas have we done the correct thing. Well, in what areas have we done the right thing for the patient and help us to provide an appropriate defense. So they guide us, they advise us. They also try to help us to avoid a claim, which is demand for money, a written demand for money, from becoming a lawsuit and all of that involves, all the time and effort. So the claim department is more than just lawsuits. It goes beyond that. They also help us with respect to medical boards. They help us with respect to depositions. Sometimes, in fact, we're not the ones that are being accused. We're not the ones that are being the defendants. But we're involved as in a deposition because of a legal matter. They also help us with informal meetings and give us legal advice. And of course, they're also there to help us with near misses. Just like with the FAA, the pilots are required, if they have something that occurs to them, to report it to the FAA. If birds fly into their engine, if their engine catches on fire, if they have a plane that seems too close to them, if they have a near miss on a runway, they're required to advise the FAA of all these problems. What's the purpose of that? It's to help other people avoid these things. Not only to help us, but to help others. And of course, one of our jobs is to help our colleagues, not only our patients, but also our colleagues to do well. Now, I'm going to provide you with a couple of examples that have come to OMIC, which are examples of claims, but in fact did not resolve in any kind of a lawsuit. The first one is a very good friend of mine, a colleague of mine, had a 59-year-old diabetic come to his office. The diabetic, as frequently occurs, needed new glasses. And so as the phoropter was coming toward the patient's head, the phoropter hit the patient on the forehead, just causing a little bump and a little break in the skin. And it was, whether it was the phoropter coming too quickly or whether it's the patient moving forward too quickly, really doesn't matter, but the patient did sustain a small bump on the forehead. It was iced down, there was a small bandage put on, and in fact the physician was so concerned that he said, let's just stop and we'll have you come back another day. But the patient insisted, I'm fine. There's no problem here. Let's finish the exam. I'd like to get my glasses prescription, and then I'd like to go on. And of course, that's what happened. The glasses were assigned, the prescription was given, The remainder of the refraction was done. There didn't appear to be any problem. In fact, the patient kept saying there really is no issue here. The physician, though, was so caring about this issue that he even called the patient at night and said, "Are you doing okay? Is there any problem whatsoever? Is there anything I can help you with? Are you feeling fine?" Patient said, "I'm having really no problem whatsoever." But of course, about 2 months later, the physician received a letter from an attorney. And the attorney alleged, "No, you struck this individual in the forehead so hard that that individual had to go that night to the hospital and was diagnosed with a possible concussion, causing, in fact, them to be dizzy and miss work for 3 weeks at substantial loss to this particular patient, this particular individual." And of course, the physician was somewhat surprised because he had called the patient that night who said, "I'm not having any problem." But in fact, there were medical records where she had gone to the hospital and been treated. And so the attorney had asked from the physician a sum of money, which is in the 5-figure range, to compensate the patient for all that they had been through with the loss of work, with the trauma to their life. And of course, this was ridiculous. It wasn't appropriate. We all recognize this as being somewhat frivolous. But at the same time, the physician did the exact right thing, which was to call OMEC and said, "I need some advice here." Some advice was given to offer to pay the patient for the 3-figure range for any kind of inconvenience or problem that might have occurred. The attorney said, "I'm really not interested in that. I really want something in the 5-figure range, or we're not talking, and we'll go to court." At that time, an attorney was assigned by OMEC to help the physician to get through all of this issue. There's, of course, some exchange of numbers, some exchange of discussion. It was recognized that there wasn't that big a deal going on here. And finally, there was a question of how much time, how much effort is going into this, and am I actually just ransoming my reputation? Finally, the decision was made. There'll be a final offer in the 3-figure range to settle this, and I'll pay this, but nothing more. And the plaintiff, the patient in this case, and the patient's attorney agreed to the sum of money. The paperwork was completed to get a release, and this was all over with. And the physician paid for this out of his own personal funds. And we're going to talk about that in a little bit, about why that is particularly important. The takeaway message from this, though, is if you have an issue, even if it's not a formal lawsuit, call OMEC. Try to get a hold of OMEC. That's what they're there for. They understand these cases. They're there to support you, to help you, to get you off the merry-go-round and get off this roller coaster of emotions which always accompanies these types of demands. Now, let's talk about another particular case. What about if there's a demand from a patient for a refund or for covering the cost of medical care? We, of course, have all had patients where, despite our best efforts, after a surgical procedure, they feel as if they would be better off being seen by someone else, or they have some question about the care that's provided to them. And they may go see another individual. This is particularly true in my area, which is refractive surgery, but is becoming more of a case with premium IOLs and other issues. So if a patient goes and seeks the opinion of another physician, that individual may say, that other physician may say, "I might go in a different course. I might go in a different direction. This is what it will cost you to do that." And those patients have and will, on occasion, call and say, "I would like you, as my original surgeon, to pay not only for the physician visit and the physician follow-ups, but also to pay for additional care." And they may actually even request a refund for the work that they paid for in the first place. So the question is, what do you do in these particular cases? Well, the first thing you want to do is report that particular situation to OMEC. This triggers your policy and the protections in your policies regarding a potential claim. The other advantage is that OMEC at that point can decide whether or not at that point in time an attorney needs to be assigned to this particular case in your particular state, because every state has their own rules regarding these types of issues and regarding the confidentiality of these types of settlements. They can also help to draft settlement agreements and keep everything as confidential as possible. So it is important to call OMEC at that point. Is it appropriate to go speak with the patient, to call the patient, discuss the issue with the patient again? And the answer is many times yes, but you may want some guidance from OMEC as to what to discuss, what are the parameters of the discussion, and how should you carry on with this? Should you obtain a release? If it's a large amount of money, I would obtain a release, and that's what we typically recommend as a company. Alternatively, if it's a small amount of money, you may not want to raise any more red flags. So you may just want to stop at that point. And again, you can get that advice depending on what goes on. What about waiving fees? Is that simply, and I've had this question by my colleagues a number of times after I've spoken at an OMEC seminar, for instance. If I waive a fee, or if I help to pay the physician's costs outside of my office, is that really just an admission for guilt? And if it ever does go to court, am I really going to find out that I should have never done that because it's going to look terrible to a jury? Well, there are a couple of things to take away from this. First of all, typically it's not even admissible in court. If it were to be admissible, in fact, typically it's looked by a jury that you're just a compassionate physician who's trying to help and trying to do the best thing for their patients, and nothing more than that. Do I have to report this to my state agencies, to the medical board, etc.? And the answer is maybe, maybe not. That's determined on a state-by-state basis. And again, that is where OMEC can help you to contact an attorney in your state, do the research for you, and give you that advice as to what your next steps are and to whom you need to either report this or not. They can also help to draft a release statement. They can also help to expedite the exchange of fees or even the waiver of fees in this particular case. Now, there's always a caution you must be aware of, and that is if you refund fees or if you waive fees, that may violate a third-party contract. It may look like, in fact, you're giving a kickback, so just be aware of that particular issue. If I refund a fee, do I have to report that to the National Practitioner Database? And I will tell you the necessity of reporting to the National Practitioner Database is based upon two things. First of all, there has to be a written complaint or claim, a demand for payment, that is made by the individual. Second issue is that the malpractice payment must be made from something other than your personal funds. If it's made by your personal funds, it does not need to be reported to the National Practitioner Database. So again, if there's no written demand for money, then it doesn't need to be reported. Number two, if you're paying this out of your personal funds, out of your personal checkbook, not the corporate checkbook, not the insurance company, then it does not need to be reported in either of those. Both of those criteria must be met. So you can see that the claims department does more than just settle lawsuits and intervene if there's a lawsuit. It's also added in these particular issues. They're also there to help you with the deposition. So what is a deposition? A deposition is a legal proceeding. It's where an attorney is there to ask you questions. And in fact, you may need representation, so it's always important to call the company, OMEC, and inform them of a deposition so that if necessary, they can provide an attorney to you to protect your interest. It may not be a deposition against your care. It may be that you're in fact have a patient who is suing another physician, but you've been brought in for a deposition. If that's the case, you need some protection also. So again, call OMEC early. Now it's important if you're giving a deposition to listen very, very carefully to the questions that are asked and answer only and specifically those questions. Don't elaborate. Don't talk about your thought process of how you got to that point. Answer specifically the question which is given. Don't give any more information. Don't guess. If you don't understand the question, if the question is vague to you, just indicate, I don't understand. I need to have the question rephrased. But don't guess at what the answer may be. Don't guess what the attorney is trying to think of or trying to get at. Ask them, what is your specific question? That's an important thing to do. Another thing is, avoid adjectives, avoid superlatives. Not always, never, the biggest, the worst. Avoid those types of things. Everything in moderation. And don't let the attorney, the examiner, put words in your mouth. Many times I've been in depositions where they've said, well, I think that you would agree with me. No, I don't agree with you. If you have a question to ask the question and I'll give you my best insight. But don't go off on trying to elaborate on their hypothesis or in their hypothetical issue. If that's the case, just stop. You're only there to comment upon your patient your patient care, what you've seen, what you've done. A lot of times they'll also ask you, well, do you think that Dr. Jones acted appropriately? Remember, the information that you've received from your patient is their interpretation of what Dr. Jones did. It's their interpretation of what they think occurred. So don't go with those hypotheticals. If you don't know the answer, if you're not specifically aware of what's going on, just stop. Don't comment on those particular things. And the most important thing, of course, is to tell the truth. Now, OMEC, fortunately, has provided a tremendous resource on its website. It's called the Deposition Handbook for Ophthalmologists. I urge all of you to read this, to look over this before you have to give a deposition. So in summary, what I've tried to express today is the claims department certainly does handle lawsuits, but handles much more than lawsuits. It's a resource to you on things that are short of a lawsuit. And in fact, many times what you're trying to avoid and what they're trying to avoid as a claims department is a lawsuit. They're very expensive. They're very difficult. They're very difficult emotionally. So they're there to help avoid anything that would hurt you, either financially or your professional reputation. They're also there to help you with refunds, letters of release, negotiating settlements. All of these are things the claims department not only can do, but is more than willing to do if you simply call them and inform them. And anybody's insurance company and anybody's claims department should be knowledgeable in this particular area. But remember, if you have OMEC, you have an insurance company which is specific to ophthalmologists. They understand the nomenclature, they understand the procedures, and they're there to help you in those specific instances. Additionally, they're there to help you on depositions or any board-related, medical board-related material. The key is you have to call. So you have to, as an individual who's a member of OMEC and is insured by OMEC, call and ask the question and ask for the help. Thank you.